discussing Florida statutes regarding limited liability companies and fiduciary duties of managers and members of the LLCs. We will focus on changes in the law and ideas for reducing and eliminating fiduciary duties in operating agreements. First, a little bit about us. Forster Bowman is a smaller law firm with most of our attorneys trained in larger law firms, and our approach is an economic alternative to larger law firms. Kathryn Jones practices in corporate law and transactions, including tax law and controversy resolution, as well as intellectual property matters, and I handle business disputes. Before we get into nitty-gritty, Kathryn, I thought maybe we could start by talking about the history and how do we get here, how we get to LLCs. I remember when I was starting back in 1983, it was all about corporations and partnerships.
Right. Well, I think in the mid-90s, I believe it was Wyoming that had the first limited liability company statute, and I think it kind of arose from the need to have, a hybrid format between the corporate, corporations and then partnerships. And so the LLC model, it really gives business owners a lot of flexibility in structuring management rights, preferred return distributions, how the money is divvied up and contributed. And so that was an improvement from the corporate world, because in corporations, it's kind of lockstep. Your shareholders elect your directors, and then they're in charge. And so this kind of gives a little bit more flexibility in structuring, the governing laws of the entity to what the clients and the business owners really need. So, with that is some concepts are borrowed from corporate law. So fiduciary duties, for example, those came out of corporate law and partnership laws. And so that's kind of where we're at right now. Is I think there was a need and a desire to have the flexibility of LLCs with some of the aspects of corporate and partnerships that were already kind of established.
So in corporations, directors had fiduciary responsibilities to the corporations. Partners had duties to the partners in the partnership. In LLCs, you have managers and members.
Right.
And it's the same concept.
Right. In the format of the LLC, at least in Florida, is you can have a member managed LLC where you don't have separate managers. The owners are the ones who run the company. And then you have manager managed LLCs, which the managers need not be owners of the company. And you can have outside managers come in that don't have no equity position, but are still in charge of operating the company.
And is it kind of the general concept between all of this? You have ownership,
right,
and you have operations,
right,
and how do you figure out how it's going to be operated and how it's going to be done fairly and to protect it against any improper conduct?
And then we'll get into this later in the presentation, Skip, but one of the common contexts you will see the concept of fiduciary duties come up and how to waive them and modify them contractually is when you have an outside investor, maybe a private equity group or an angel investor who is being brought in to help a business that may not be doing so well. So they're bringing in expertise and capital, but they want to limit their exposure to claims which may arise in the conduct of their management of the company. And so we'll talk later about some language and some tips as far as how that will play out in practice.
Why don't we hop into it?
All right. I'm going to turn the video off here so you can focus on the slides. Hopefully I will do this correctly. Here we go. Okay. So this is really kind of the bird's eye view of what we're going to be discussing today. We'll start with the statutes themselves regarding the fiduciary duties. Part 2, we'll get into how to modify these in the LLC Operating Agreement by contractual agreement. 3 is kind of where Skip is going to take the lead here as a litigator, kind of where this goes in practice. When we were preparing for this seminar, Skip had a great little line where it's the writers and the fighters. And so I'm the writer, he's the fighter. And so in part 3, Skip will provide some insight and anecdotes as to how this plays out in litigation. Part 4, we're going to discuss really some kind of key tips and takeaways as you're structuring your business relationship with a business partner. And then we'll have some time for questions towards the end of the seminar. The first few slides here, we cite some statutes, the LLC statutes regarding fiduciary duties, and I wanted to kind of go back to the history. In 2015, the LLC Act was modified with respect to fiduciary duties, and there was a great article written by a gentleman named Louis Conti, who he discusses kind of this concept of cabining in, where prior to 2015, courts really only looked at the codification of the duties of loyalty and care in the statute. After 2015, which is where we are, present day, is that courts are they're uncabined in that they can look beyond the statute and look at equitable principles, and it really gives the courts the ability to fashion appropriate remedies that may not be found strictly in the language of the statutes.
Well, just so folks understand, when we're talking about common law and statutory law is developed by the legislature, passed by the legislature, signed into law by the governor, and lays out rights and obligations of parties and how the law is going to deal with it. Common law is where trial courts decide matters of law, and the courts or juries determine matters of fact, and then those cases get appealed. And the appellate courts will write written decisions applying the law to the facts of the case, and those decisions become the common law that lawyers and parties can look at in then determining what they're going to do next and how the law applies to their particular set of facts. So what the statute was doing was saying, in addition to the statutory rights and obligations and remedies we're putting here, also the courts can look back at what other courts have done in other factual situations applying the law and fiduciary duties.
So what's in the statute? We cited here section 605.04091 Florida statutes, and this applies to members in a member-managed LLC and managers in a manager-managed LLC. So this is where kind of the form of the LLC comes into play, in that members who are in a manager-managed LLC don't really have fiduciary duties because they're not in charge. So this really, the duties are imposed on the people who are making the decisions. And so one of the duties is this duty of loyalty. And so we've listed here some of the key elements of the duty of loyalty, where I think, obviously you can't steal from the LLC. You can't hold any benefits for the LLC or for yourself that really should belong to the LLC. And where this seems to come into play is appropriation of LLC opportunities sometimes, and competing against an LLC in which somebody is a manager or is a member who manages the LLC. And
how is the duty of loyalty different from a conflict of interest?
That's a great question, Skip. I think the duty of loyalty, there are ways to, let's say if a member wants to transact or a manager wants to transact with his LLC, they have a duty to treat that LLC fairly in these interactions. And so just because somebody is, may have an adverse interest, like an example is a real estate deal where the LLC may rent real estate or want to rent real estate from a manager or a member. So that manager would be in charge of, the LLC and causing it to enter the agreement, but they'd also be wearing the hat of the landlord. And so, there is a duty of, the duty is there, they're conflicting, but there are ways in that particular circumstance to kind of sanitize the transaction from a conflict of interest standpoint, which we'll get to later. But I think, one of the key takeaways is, the duty to not compete with the LLC applies regardless of whether or not you have a written non-compete agreement. And sometimes people may not be aware of that duty that's in the statute. So, there needn't be a written specific restrictive covenant binding a manager. It's great if there is one. We often do write those into the operating agreement, so it's absolutely clear what the duties are. But in the absence of a written non-compete, there are still some statutory obligations that managers have to the LLCs to not compete.
Where this comes up in litigation is oftentimes when there are multiple members within the LLC and one of them wants to go out and do the same business or similar business, and then they start doing that, which is an obvious conflict and adverse to the company.
And I've seen situations where maybe the business is doing well for a while, everyone's in it, and then it starts to go south. And so maybe one of the managers is like, hey, I could probably do this on my own and better. But before they do that, they have to wind up and they have to kind of conclude their service to the LLC before going into a competing venture. Other fiduciary duties that we'll touch upon now and talk more about later are the duty of care. There's a duty of disclosure, and we'll talk about those in specific detail later. Regarding the duty of care, there's several levels of care here, and this is where later when we talk about how to waive these, you can modify what it means to abide by the duty of care when you write the operating agreement. But typically, the statute says it's a violation of the duty of care if a manager engages in gross negligence or willful misconduct, or reckless or knowing violations of the law. That's written into the statute. And then a defense to the breach of duty of care is this good faith business judgment rule. And Skip, if you had any comments on that or on how that plays out, that'd be great.
Yeah, a couple comments. First, when you're talking about these statutes, this was the way LLC statutes have been around the country. These are common duties that come up in other statutes before we get to the specifics of the Florida statute. So for ordinary care, that's typical negligence. That's the failure to exercise the standard of care that a reasonably prudent person would have exercised in a similar situation. That's different from gross negligence or willful misconduct. Gross negligence is very bad negligence, and that's where it's conscious, involuntary act or omission in reckless disregard of the legal duty and of the consequence to another party. The business judgment rule, that was something that came up with directors and corporations, and it was a presumption that in making business decisions not involving direct self-interest or self-dealing, a corporate director would be acting on an informed basis and in good faith, and in the honest belief that their actions are in the best interest of the corporation.
I think that brings us into this point 2D here, the manager's reliance on information provided by others. The manager, again, they need to reasonably rely on professional advice, and that if there's, if the particular professional may be acting outside of their area of competence and giving an opinion, that may not necessarily be a reasonable reliance, and therefore the business judgment rule potentially may not apply to insulate that manager from liability based on a breach of his duty of care. The duty to disclose, again, managers, the people who are operating the business are often in a position where they have more information than maybe a passive member would have. And so there's Delaware corporate law, which seems to translate into the LLC world, is that there could be a duty to disclose by the managers to the members. And so in this Metro Communications case, which we've cited here, the court found that the managers had a duty to not mislead members in their disclosure to the members in relation to a capital call. So if a manager is approaching the members and saying, hey, we need more money for the business, we're going to, trigger Section X of the operating agreement, which requires you to make a capital contribution or else potentially be diluted or have your distribution suspended or whatever consequence is provided for in the operating agreement. And so in communicating that, the managers, cannot mislead. And mislead, I think, could be an act of omission where they're not giving the members the full financial picture, or it could potentially be an actual deception in these, egregious cases.
Is a duty to disclose absolute?
No, it's not. In Florida, anyway, it's not absolute. There's a section in the statute that talks about a conditional duty to disclose, where the member has a right under the LLC Act or the operating agreement to vote or consent on a matter. So in manager-managed operating agreements, particularly when we're asked to draft them on behalf of the managers or the majority member, the minority members have, only a few things that they are entitled to vote upon. And there's also certain actions that require the approval of members that are provided for in the statute. So for example, major actions like the dissolution of the company or kind of organic changes typically require the members to vote and consent. So this conditional duty to disclose, would not apply. A manager would not have to disclose something or information to a member if that member has no right to really have a say in the matter. It's probably nice, I think, in a as far as goodwill and kind of cultivating trust within the LLC, it's a good idea for the managers to be transparent, but in Florida, it's only a conditional duty to disclose.
So could you have a combination where there's a situation where there's a duty to disclose and a duty of loyalty? Like one would be not talking about the transaction, which would be disclosure. The second would be taking advantage of it.
Mm-hmm. I think they do play together, and I think, you know, in the perfect storm, if you're arguing that an action was improper, you could probably, you know, make arguments under either duty to hold the manager or the member who's making the decisions liable for things that may cause harm resulting from the failure to make proper disclosures or to maintain loyalty to the LLC. We mentioned earlier these conflict of interest transactions.
Can we go back to that
one,
one,
of course.
Mm-hmm. So because that's what the statute says, only on that particular circumstance, then it would still be up to the court going over to common law to figure out whether there's been a breach of fiduciary duty for any other failure to disclose.
Agreed. Conflict of interest transactions. We alluded earlier to a scenario where you know, there may be a commercial reason or a business reason for an LLC to transact with one of its members or managers. The statute here, 605.04092, provides a mechanism by which these types of transactions could be, you know, for lack of a better word, sanitized. So it could protect the transaction from being deemed void or voidable by a court if somebody ends up being unhappy with the outcome later on. And so a key to this statute is disclosure. So there's disclosure and approval by non-interested members or managers. There's also an element of fairness. In the phrase "fair to the limited liability company" is defined, and there's a very intricate definition in the statute. But the fact is, there has to be fairness in both the substance, meaning it has to be comparable to what the LLC may have obtained in an arm's length transaction, as well as fairness in the dealings that the members and managers who are interested have with the LLC. So I think ultimately the fairness aspect is implicated when there's a disclosure issue. You want to make sure whoever disinterested members or managers are who are being asked to authorize the transaction have the full picture, and that they have the information that they need to make an informed decision.
Going back to the example you gave at the very beginning of the presentation about where a member would have real estate and the LLC would be renting it, how would that work in this type of situation?
Sure. I think in that transaction, it's probably pretty easy to figure out without an arm's length, because you could have market comps, or you can have a broker or realtor involved to give an opinion as to, you know, what a fair market rent would be for that particular property. Of course, you know, I think it's, I mean, I think what happens is that maybe you have that as a guidepost, and then there may be a little bit of, you know, negotiation back and forth, given that the parties are linked. But I think in the real estate example, you know, you want the price to be fair and also the terms to be fair. In terms of the lease, you want it to be comparable to what an LLC would find in the marketplace when they're trying to rent the same space. And so who proves lack of fairness? Really, under the statute, if you follow these procedures, whoever's challenging the transaction has a burden of proving the lack of fairness. The proponent of the transaction doesn't have to prove that it's fair. The challenger has to prove that it's unfair, and so that this would behoove the interested manager to follow these procedures and to make sure the disclosures and approval is sought under the statutes. As far as approving it, there is language in the statute that says you need at least 2 disinterested managers to approve. This could be a practical problem that, you know, if you only have one other disinterested manager. And so if in a manager managed LLC you can't hit that standard, there's a way under the second portion of the statute for the members to approve. We talked a little bit earlier about the member managed versus manager managed LLCs, and the issue, depending on the structure, is whether to whom the duties run. And in a member managed LLCs, The members owe fiduciary duties to the LLC and the other members. That makes sense because everybody has a say in how the LLC is operated. Point 2 here is important, is that just because an action furthers a member's own interest doesn't necessarily make it a violation of the duty of loyalty. So in the real estate example, of course, the member who owns the real estate is going to want a tenant. They're going to want to fill it in the space. But if it's also a good deal for the LLC and that maybe that's hot space that they can't get, it's a great location for the business, there could be a win-win. And in that situation, just because the transaction on paper may have a conflict, it doesn't necessarily mean it's a bad thing for either the member or the manager.
Yeah, what per se violation means is it's automatic. It's presumed that because you've taken an action in furtherance of your own interest, that would be a violation of duty of loyalty, and that's not the case. It could be, but it's not automatic.
Right. And the same applies in a manager-managed LLC. They're just because a manager's own interest is furthered by a transaction does not necessarily make it, the type of transaction that would be actionable for breach of loyalty.
And the reason why members don't owe fiduciary duties is because they're owning, but if it's manager and managed, the members aren't operating it; they're just owning it, so they wouldn't have fiduciary duties.
So part 2 of our seminar here is how do we, now that we've kind of laid the groundwork as to what the LLC statutes say, how do we waive it? How do we get around it if we want to get around it? And so this would be done in the LLC Operating Agreement. It's a contract, like any other contract. The parties are free to, within certain boundaries, agree on how they want the LLC to be operated. And so in the Florida statutes, this section here, cited 605.0111 subsection 2, specifically allows fiduciary duties to be restricted, expanded, or eliminated in an LLC operating agreement, except for those provisions that are not waivable under this separate section. And so really that just gives a lot of leeway. That gives a lot of discretion for the parties to the agreement to fashion rules that are going to work in their situations.
So as a writer, and you're coming up with transactional documents, and you're working on the operating agreement, are you trying to draft around the statute? Are you trying to draft
that's
with
a
the
great
statute?
question, and that depends on really who we're engaged to represent. And so if we were to represent a minority member, we would want to hold the majority or the manager to a very high standard of fiduciary duty, because that would protect our position as the minority member. And so from that perspective, we're going to want to tighten it up. We're not going to want to waive a lot or eliminate a lot. We may even want to add, take whatever the baseline is set in the statute and add on. If we were, on the other hand, representing the majority member or the manager, we're going to want to kind of shield, to the best we can reasonably, the management from liability exposure for fiduciary duty breaches, particularly in a situation like we mentioned earlier with an angel investor or a private equity fund, where they may have several different boards that they sit on, and they may not necessarily be in separate industries. And so from that perspective, we'd want to kind of chip away at it to the extent permissible under the LLC statutes. So there are certain provisions that you cannot waive, and one of these things is the operating agreement cannot exonerate somebody from knowing violations of the law or intentional misconduct. I mean, that's just, and there's a policy reason for that. You don't want to be able to contract your way around a bad action. So the takeaway here is egregious breaches of a duty of care can't be contractually excused. There are ways to eliminate the duty of loyalty. And I think, and we'll talk about this concept more later, but you cannot do so in a way that would be manifestly unreasonable. And what that means is, we'll get into that later. But you can, in modifying the duty of loyalty, you can specify the way which a potentially conflicting transaction can be ratified or authorized. So you can make it easier. I think you can make it easier to pass that threshold to sanitize the LLC.
Is that like setting up a mechanism ahead of time where the parties can waive conflicts, disclose conflicts, and just dealing with the situation?
I think so, but I think there are limitations on that. Certain conflicts, if you take it before a judge, they may just decide it's just so, it just may not be waivable. It may just be of the type that, okay, it just may kind of pass that manifestly unreasonable standard, which really serves as a safeguard for a court to kind of come in and apply equity if it warrants it in the situation. And so, you could also, the obligation of good faith and fair dealing, that could be, they can't necessarily be eliminated, but the operating agreement can specify how that duty is fulfilled. Okay. So the manifestly unreasonable standard, it allows members to eliminate or reduce fiduciary duties in their operating agreements if doing so is not manifestly unreasonable. And I think ultimately this comes down to a facts and circumstances test. Whether this were to come before a judge, I think they're going to look at a number of factors. And here we cite some language from the statute as to what the court's standard of review is. And it's it's readily apparent or it's not a reasonable means. So I think it has to be pretty bad. I think it has to be, an egregious conduct where the court is going to come in and step in and say, hey, you've gone too far.
That's why at the very beginning I was talking about standard negligence and gross negligence. There's bad, how bad, very bad. This is very bad.
Right. And generally, for the most part, Skip, would you think that courts are usually show some deference to the business judgment? I mean, I think, my understanding is that they're not going to come in and second guess if there's a reasonable basis for, why a manager took a certain course of action.
Well, there's a couple of interesting things in answering that question about this statute. And one of them is that it says specifically in the statute, the court shall make its determination as of the time the challenged term became part of the operating agreement and shall consider only circumstances existing at that time. I think the fair interpretation of that is it doesn't matter if somebody has a new idea or is making really good money or whatever's going on today. What were the circumstances that existed at the time that the parties agreed for the waiver? And at that time, under those circumstances, was it manifestly unreasonable? Would you agree with that? And the reason why I'm bringing that up, talking about the fight or right or difference, is does that make a difference then in how you prepare the operating agreement? And maybe do you put what's important in the wherefore clauses, what the circumstances are at the time, what the agreement is really about?
I do, and you have to take into account kind of the posture of the company at the time, at least from when they approach us. Where are they in their business cycle? Are they just starting? Is everybody on good terms? Is there any reason to anticipate problems? Or are they maybe later a more seasoned business where they're bringing in a new investor and there's a history there and you want to protect against things going forward after somebody comes in and invests money or becomes a manager? And so context is very important in that situation. And I would think the newer, kind of the fresh LLCs, you may not know what to draft for, what to anticipate, but as a business kind of progresses, you start figuring it out. And I think it's important that in particular is if there is a huge change in circumstances, you would want to revisit that operating agreement and make sure it's going to align with your current needs, because oftentimes if things are going well, people sign it at the beginning of the business cycle and then they forget about it until there's a problem, and then you're going to have to fight over it in litigation. So one of the things that we recommend to our clients is if you bring in a new member or somebody leaves or somebody dies or the composition of the organization changes at the top, then you're going to want to revisit your operating agreement, make sure it still works. You may also find in multi-generational businesses, what was good for dad may not be good for son. And once that torch is passed, you need to adjust the governing documents to reflect the actual needs of the business at the time.
Before I answer the rest of your question about what the courts look at, the collaboration that you're describing, Kathryn, I think is really important for our listeners and viewers, because it's not just the collaboration between the client and the lawyer, which is what you were describing, but want them also to understand that there's important collaboration that takes place at our firm, at least, between the writers and fighters,
Right.
because we frequently have communication about what has come up in litigation about a document, whether it's our document or somebody else's. And often the times the writers will run by different provisions in agreements and say, have you had any experience in litigating these? Or what do you think about this? And that collaboration makes it for a better work product. Going back to your question about what they're looking at, one of the things that keeps popping into my mind is a saying that's been around for a long time, that equity is as long as a chancellor's foot. And what that means is, in courts of equity, there used to be chancellor judges, and those judges would determine what they thought was reasonable and fair. And what they come up with, particularly when there isn't a lot of guidance from the legislature, which I would argue is the case here, and there isn't a lot of developed case law because the statutory law has been changed, and that's recently, which I would argue is the case here. It's up to what the judge thinks is fair and reasonable based upon the circumstances, the operating agreement that's in front of them, and as good of a job as the lawyers do in arguing their case.
One of the things that we kind of look at from the writer's perspective is, do we want this to ever come before a jury? Or do we want to write into the operating agreement that you're waiving a trial by jury and the judge is going to hear? In complex business matters like the ones that you and some of our colleagues handle, is there a preference, and is there kind of a rule of thumb where we're going to write it in unless there's a good reason not to?
Well, a couple things. The statute in this particular case says the court determines as a matter of law whether it's going to be manifestly unreasonable. So that question doesn't get to the jury. It really depends upon the type of a case in a business dispute, whether you want a judge or jury to determine it.
But this issue of manifestly, and the reason I ask is because it seems very technical. And so it would seem like the judge is better suited to make that ruling. And then if there was a jury trial, they would decide other aspects of the
We're going to find out,
right?
because there's not a lot of cases
Right.
that have made it up through the appellate level since this law changed in 2015.
Okay, so I think we touched on some of these, but some of the factors that a court looks at are the relative bargaining power of the parties at the time they entered into the agreement. Again, going back to the timing aspect of it, prior dealing. So I think also that ties into the situation where you've got, maybe a new member coming in or a new manager coming in. And then the general business practices of the industry in question. So can you think of any other factors that a court may look at? I'm assuming that this is not an exclusive list and it's just a matter of discretion.
It's the ultimate discretion of the judge. What's reasonable and fair under the circumstances at the time? Was one party trying to take advantage of the other?
Do you think that really, could the judge also look at things like if somebody is elderly or infirm, or or if there's maybe some kind of unfairness there in dealing with somebody who may not be as savvy or as competent as a manager who is under scrutiny?
I don't think so. But the reasons why I think that is that there are other statutory provisions to protect people that are in vulnerable situations. And also, typically, Florida courts don't look at whether the deal is a bad deal. They look at whether it's an enforceable deal and whether the provisions of the agreement are in compliance with common law and statutory law.
And so frequently, in my experience, the ask for a waiver of fiduciary duty or a modification doesn't come up that often. Where we see it typically is with private equity groups, and they're in the business of holding portfolios of operating businesses and making money. And so some of the management, the upper level management in these private equity groups, they may be sitting on multiple boards. and they may not want coming into a new LLC to cause an issue with another LLC or business that they've historically served as a board member or manager for. And so this is where I typically see it is if we're representing the company that is taking in the investment that needs the additional cash infusion, the other side may ask for specific language in the operating agreement to help insulate their client, the incoming manager, from liabilities for breach of fiduciary duty claims. Again, without that, would there be an issue under the duty of loyalty that they're competing with the LLC? Absolutely. And so from that perspective, it would then be up to the client, whoever is bringing in the money, to say, hey, are we willing to, is this something we can stomach? Is it something that we're willing to give up in order to get this person on board, to help us grow the business, or to bring in their capital? There's a lot of text, and please feel free to read it offline when you have some time. But this is a provision, it's a modified version of something that we've drafted. And it hits kind of on all the different aspects of the fiduciary duties. And so the first couple lines talk about the duty of care and the ordinary prudent person standard. So we're not holding, in this situation, we're not holding a manager to a level, that he may be held to because of his expertise or his savvy. They're just an ordinary prudent person, under in the same position. The next clause here, no personal liability unless there's bad faith and gross negligence.
So in that first clause, does that potentially insulate a manager who, let's say he's an accountant,
right,
or a lawyer, and a lawyer, let's pick a lawyer. A lawyer ought to know better than to violate the statute.
That's a great question, Skip. And I think in the lawyer situation, there may be other rules at play, like the rules of professional conduct, that there may be something similar or analogous in the CPA universe. But I think the counter argument is, okay, well, we agreed to this. This is consideration for me coming on board, bringing my expertise, bringing my background, is that, I'm going to be just held to an ordinary prudent person standard.
But the idea is that somebody who has more expertise is going to be held to that standard, right?
Right.
And so when we were talking earlier about who you're drafting it for, potentially if somebody has that expertise and you want them to exercise it, you want to say that, right?
Yeah.
If you're the person with the expertise and you don't want to be held to that high standard, you want language like this.
I think in a perfect world, you would want them to feel free to exercise their judgment without necessarily being, pigeonholed into liability. So
the flexibility.
They may want this person to come on and be willing to take risks and maybe think outside of the box, but that person may not want to, be exposed for taking actions that may be risky. And so, so that those first few lines talk about the duty of care. And then the next few lines talk about reliance on information. And so when we're talking about what the manager can rely upon, there is this notion that they have to reasonably believe that the opinions are being rendered within the person's professional competence.
That's going back to the business judgment rule that we were talking about earlier. Well, I have a question about that one.
Certainly.
So what if the manager is relying upon information from a layperson, not a professional person? This kind of refers to somebody who's professional, but suppose they're relying upon boots on the ground, and then is that okay?
I read this as, you could, so long as you don't have reason to believe that it's bad information, right? So I don't think this is necessarily limited to, you can only rely on professionals or people with certain credentials. But if somebody does have knowledge and information pertinent to an issue that's being faced by the LLC, that the manager has to make a decision upon, so long as that information, I think, is credible, or they could reasonably believe it's credible.
Does the standard keep going back to belief in good faith that's in the best interest of the company?
I believe so. And then the last few lines specifically address the duty of care. And again, going back to the situation where you may have somebody who is very seasoned in a particular industry, and they sit on multiple boards. And so their duty to one LLC that they serve may conflict with their duties to another if they're competitors in the same industry. And so from that perspective, that manager is going to want some limitations and permission to continue serving on the board that he is serving on before he comes in to serve on another company's board.
I thought one of the most important lines in this operating agreement provision was that the parties expressly agree that the alteration of certain aspects of any manager's duty, including the duty of loyalty, is not manifestly unreasonable.
And that's something that it'll be interesting to see if there's case law developing that, where the court could say, oh, well, you've agreed to it, so does that stop? Does that preclude somebody from coming in and saying it's, it is manifestly unreasonable?
Well, I was thinking about this after we talked a couple nights ago, and I'd much rather have this in your document and let me litigate it than litigate at the end whether it was. I'd rather be litigating, oh, they've already agreed it was fine, and now they want to bring it up again.
And I think that's kind of the whole point of the operating agreement. Again, it depends on who you're representing, but you want to put them in the best position to make those cases and make the arguments and have the arguments there available in the document for the fighters to make. And so, a lot of companies, smaller companies, may not have an operating agreement, and you don't have to have one to form and be organized in Florida, but it's a very good idea to have one, because if you don't, then the statute is going to fill in, and that's going to be the default position. So if you're in a situation where, you're a member, you're trying to bring in new capital, or, you want to invest, you're the investor and you want to protect yourself, one of the things you're going to want to ask is, can I see the company's operating agreement? Well, if you don't have one, there's your time as the investor. That's when you have your leverage, is to say, okay, for me to get involved, we're going to have certain things in there to protect me. And again, it kind of goes to that kind of proactive, the vaccine, not the cure, kind of the vaccine. You want to make sure the contract is well drafted as part of taking in capital and new investors. Okay, so part 3, where the rubber meets the road, I guess. Skip is, have you come across anything either in your practice or in researching recent case law that can help kind of illustrate how these concepts are applied?
Well, yes, and let me start with this. When you look at the statute, and as Kathryn's described it, you can see that it allows the court great latitude to determine what's reasonable, but it really doesn't give much guidance to the parties or courts on exactly what is going to be okay. Guidance really takes and points out what's obviously unreasonable, right? And so then there's lots of grayness, and the trial courts have a lot of discretion. And there's not much case law yet in Florida. We talked earlier about how part of the genesis of our statute and case law regarding business entities comes out of Delaware. And there's been some cases from Delaware and other jurisdictions. And it's interesting as this is developing, because there's not a lot of commentary explaining exactly why a provision is manifestly unreasonable. And we're just going to have to wait and see while courts catch up in interpreting the law. But we do have some examples. There are 3 cases that I found since 2015 that deals with standards of conduct for members under 605.04091. All 3 are from the bankruptcy court, but they still help. The first dealt with what was a breach of fiduciary duty. And in that case, a promoter of real estate development breached his common law fiduciary duty to its investors, the court found, as well as the statutory duty of loyalty under Florida law, in causing an option to acquire real estate to be assigned, not to the limited liability company that he formed to hold and develop the property, but to another entity, which he controlled, for the sole purpose of enabling this other entity simply for acting as a straw man in connection with the LLC's purchase of the property, to collect for the promoter's benefit $1 million of the $2.5 million that he solicited from investors. Pretty outrageous.
Yes.
Okay.
Agreed.
The second case, in that case, dealt with what could be waived. And under Florida law, the court found, well, members of limited liability may not agree to eliminate their statutory duties of due care, loyalty, and good faith. They may agree to limit such duties in an operating agreement. And they found that they could identify specific types of categories of activities that do not violate their duty of loyalty, as long as the agreement was not manifestly unreasonable, and may also determine the standards by which performance of duty of good faith is to be measured. That was the extent of it. The third case dealt with fiduciary relationships and said under Florida law, statutory fiduciary relations between limited liability companies, managers, and investor members was sufficient to support the investor's member claim against managers for an accounting. I don't think much of that case because I think there's a duty for an accounting anyways. Mm-hmm. But the first one was interesting in that the conduct was so outrageous. I could not find, even looking this morning, for any reported appellate cases on operating agreements for 605.0105 and for conflict of interest under 605.04092. We're just still waiting.
They may see that they haven't, they've been resolved and not appealed. So
maybe the operating agreements are really ironclad. But you were giving an analogy about the importance of the operating agreements, and I liken it sometimes to dental care, right? If you go ahead and you floss and you brush and you gargle, and you get your teeth clean, you see your dentist once a year, it's a little painful. It costs a little bit of money, but it's not as painful and as expensive if you don't do it and then you're facing it. And I find the same thing true as a litigator about the documents of the transaction at the beginning, but in particular the operating agreement, because that can lay out easily for a litigator how it's going to be litigated and what the rights and responsibilities are. And my experience has been the better the operating agreement, even though it might be a little painful and expensive at the start, is a lot less expensive and painful than a bad one that you have to litigate later.
Or none, I guess, if you don't have one, right? Before we moved on to the last segment of our discussion, I wanted to kind of ask you, Skip, about the duty to disclose and how that interacts with statutory duties and rights to information that the members may have in the LLC operating agreement. So if I'm a member and I'm not getting information from the manager, and I come to you and say, Skip, how am I going to get this information? Am I better off going under the fiduciary duty route where they're supposed to disclose it to me, or under another provision in the statutes?
I think you do both.
Yeah.
I think you do both, and you give them the opportunity to violate both.
That makes sense. And then, all of us talk about statutes and contracts and everything. I think, this last section, we're going to talk about this concept of knowing your business partner, KYBP, and that's
I love that.
Kind of a takeoff from the KYC rules, know your customer in banking. And so, in preparing for this seminar, Skip and I've written stuff and he's had to litigate based on some documents that I've prepared. And so, we were kind of sharing stories, and I think our takeaway from both the writer and the fighter's perspective is the client really needs to know who they're getting into business with, and that happens before the lawyers even get involved. Again, things to look out for, if someone is willing to sign anything without reviewing, or there's no pushback, or things are just too good to be true, that may signal that this person, even they can sign anything, but they may not necessarily abide by that, or you may be fighting over it later.
And the opposite is true before and after you get the lawyers involved. When you are asking for reasonable terms like disclosure and other things, and you're getting pushback from that there are very reasonable requests you're making for documentation and agreement, and you can't get it. That's a huge red flag.
Right. And then part of that is being upfront and discussing candidly certain topics that may be difficult to discuss. One is money, obviously, money coming in and money going out. In the next few slides, we lay out some issues that should be talking points early on, even hopefully before the lawyers even get involved because it'll help resolve issues and make the legal fees and the cost of preparing the operating agreement a little bit more manageable. Some money in and out. Who is contributing what? Property, services, cash, land, whatever. That should be discussed. And also, what happens if somebody doesn't contribute what they promised? And so, I think Skip, you and a few other of our litigator colleagues here have had a situation where people sign an operating agreement, but someone doesn't deliver. And then what happens to their interest? Are they diluted? How is that remedied? And so that would need to be discussed, hopefully up front. Money going out, distributions, how are people going to get paid? If they're not all going to get paid at the same time in proportion to their interest, how is that going to be handled? How are profits going to be split? And
well, I was going to say the concerns are the same for money coming in as money going out, but I think they're more amplified when it's going out. And the arguments about who gets what once there's a lot of money coming in can become pretty dicey. And it's better to have figured it out before the big money comes in.
Right.
How are you going to divide up the big money when it comes in?
Absolutely. And also compensation. If a manager is also employed by the LLC, what's their comp versus their distribution? How are you going to figure out, if they get paid their salary and how much is paid to them before everybody splits what's left over? Buying into an existing company. This recently came up where, we were asked to represent somebody who was selling half his company. We got the documents together, and then very late in the process, it became apparent to us that they had to discuss some basic issues. And so in that case, we went through the exercise of drafting, but no one signed anything because they reached an impasse before they had to come and ink the deal. So always good to get these things aired out ahead of time.
That was probably the best resolution.
Yeah, and looking back, it was. I mean, it was one of those things where, unfortunately, the client didn't get the result that they wanted, but it was probably okay given that they were so far apart on some, pretty basic fundamentals. So I do want to, leave some time for questions or a summary or Skip, do you have any final words or comments before we open it up to questions?
Well, a couple things. The big takeaway, I think, is first making sure that you know who you're getting into bed with in business. The second is to make sure that you get the relationship documented as favorably to your position as you can at the top of the game before the game even starts. You don't want to wait until the fourth quarter and then try and figure out what your rights and remedies are. And the last thing on the litigation front and the law, at one time when these were first coming up, the LLC statutes and the questions about waived fiduciary duties, a commentator wrote back in 2006, 2007, is this a license to lie, cheat, and steal? And there's not enough case law to know yet whether that's the case, but you can help prevent someone from lying and cheating and stealing from you if you have a good operating agreement put in place at the beginning of your relationship.
Thanks so much for joining us. On that note, I wanted to pop back in and say bye, and thank you so much for attending our webinar. If you have any questions for either Skip or me, feel free to email us with our contact information. It should be in the presentation materials. Thank you again.